Let's talk about what we know and what we don't know. They are the biggest cheaters of all time outside of Ann Arbor, Judge, and there should be consequences. You're going to be in this homeowners association. You have to do things our way. Suck. Boom. I want to weigh in. So you have a question and you're like, whoa, I wish I had access to a lawyer. Let me ask Reddit. I got a better idea. Ask a lawyer, but not just someone who went to law school and therefore they're a lawyer. Ask a trial lawyer the question. That's what I do for a living. I stand in front of juries and I fight for people who are hurt. Not just one of these guys and they're on TV. Around here, we're built to fight and we do fight. So let me see if I can help you with some of these things. First one, poisoned at work. That's a bad start to the day. Let's see. So I work in a manufacturing company of about 35 people. The other day I came into work, made my cup of coffee and got to my work area. I left my coffee on the workbench about 10 minutes, too hot to drink. When I returned to my work area, I took a big sip of coffee and immediately noticed something wrong. My mouth instantly went dry and my sinuses burned. I spit the coffee out, but it swallowed some. It's getting worse. A food manager saw this and asked me what happened. I told him something was wrong with my coffee. We both smelled it and guessed it was isopropyl alcohol. He said I needed to go to upper management. I think you needed to go to the doctor or a hospital, but see what happens. I did, and they contacted poison control, but I couldn't say for sure what I had consumed as we have hundreds of chemicals in our shop. They advised I drink water and monitor my condition. Well, that's reassuring. What concerns me is this was the end of it. I'm 90% sure I know who did it, but there is no real proof. Management hasn't even talked to anybody. There is no way possible the chemical got in there accidentally because my work area is far away from where these chemicals are kept. I'm just really disappointed and unsatisfied with how this was handled. Should I, or is it possible to take this any further? All right, let's talk about what we know and what we don't know. First, he's at work. That's game changing. Why? Because most states have an exclusive remedy at work. What's an exclusive remedy? It's a trade-off. If you're injured at work, you get the access to workers' compensation. Great thing about workers' compensation is that it doesn't matter who's at fault. If you get hurt at work, you're covered. What's the downside to workers' compensation? You don't even get your full amount of lost wages in most states. You don't get pain and suffering. You give up a lot of rights, but you do get some rights depending on the situation. In many states, if the person who hurt you was outside of your work, so you drive a vehicle for Domino's to deliver pizza and you get hit by someone who runs a red light, you have the advantage of workers' compensation and you're able to go after the person who ran a red light who doesn't work for Domino's. But here, whoever caused this person an injury works for them. Management probably didn't know and therefore they were only negligent. So can whomever wrote this go after the company? Probably not. Probably limited to exclusive remedy. However, they may be able to go after the person who put it in the coffee. Why? Because in many states, intentional acts are outside of workers' compensation. But remember, you have to be able to prove it. Next one. Whoa, neighborhood kid possibly hurt on our property. I hope not. I'm glad it's only possible. Let's see what happens. The thing they always say will happen, happened. A 6-year-old from down the street apparently broke his arm on our trampoline while jumping with my kid. We don't know that for sure. Nobody brought it up at the time. He supposedly started feeling it during karate class later that night, and they took him for x-rays to find out it's broken. Mother texted my wife the next day and said he had a broken arm and my kid had landed on his arm. The father came by today and chatted with me in the driveway for a bit. Most of his conversation was based around how he's broke because he's waiting on 3 different lawsuits to pay out. Just don't have a lot of people waiting on 3 different lawsuits to pay out. But anyway, the feeling that I got was he was waiting for me to offer money, but he never asked and I never offered. It's a neighbor and our kids are friends, so I'd like to salvage the relationship best I can. All right, ask an injury lawyer. I got you on this one. Let's go piece by piece. Number 1, you have a responsibility in just about every state in this country to have safe property. Number 2, when a child is under your supervision, there's also things related to that. So even if you had taken someone else's child to a trampoline park, there's potentially risk there. What is the risk? If you act negligently in allowing it. What can happen with this? Number 1, should you be paying money? No, probably not. You probably, if anything, should turn it over to your homeowner's insurance, which likely, not for sure, there could be exclusions. Most people think a homeowner's insurance is, God forbid their house burns down. But actually, it often covers negligence or alleged negligence of a homeowner. So let's talk about the law. 1, are you at fault because someone says they got hurt? Well, first, do we really know when the kid broke his arm? I'm not attacking a 6-year-old, but if you break your arm badly at any age, usually, and there's lots of exceptions, you know it. 2, karate is a contact sport. right? At least to some degree. 3, there was time between your house and karate. Now listen, I'm not saying he didn't hurt his arm on your trampoline. I'm just not saying it's a given simply because they say so. That's number 1. Number 2, let's say he hurt his arm on your trampoline. Did his parents know the risk? Did they allow the kid to jump? Is it negligent of you to allow the kid on the trampoline? These are things that a lot of people on the internet love to tell you the answer to. And the truth is they are what we call jury questions, meaning there's no legal answer in most places outside of what do people think? And to that degree, we have to know who was watching the kid. What did the parents know? Did the 6-year-old do anything that a normal 6-year-old wouldn't do? Now at 6 years old, not really even sure what that is because who knows what a 6-year-old will do. We don't know if you did anything wrong. We don't know if he was hurt. Depending on the state will kind of dictate the law of all this. We don't know if it's serious. The good news, I'm hoping it's the good news, is if he didn't know it was hurt until karate class later that day, then maybe it's not surgical. Maybe it's a hairline fracture literally 4 weeks later with a kid this age. It's healed stronger than it ever was, and it barely limits his life, in which case it's not worth a lawsuit for the kid probably, and nothing to worry about. So how would I sum all this up? 1, put a net around your trampoline if you're going to have them at all. The reality is that you started this, what they always say will happen, happened. There are risks associated with pools and trampolines and so forth. I'm not going to tell you what to do, but you have to accept those risks because the truth is those are real situations and people do get hurt and they're potentially avoidable. So consider that. Number 2, if you get sued, don't freak out. Call up your homeowner's insurance and ask them to cover. Right now, there's no lawsuit. Hopefully it's not very severe. You may not even be responsible. He may not even broken his arm here. And in the future, the best I can tell you is you seem to be coming from a good place. Be careful with those trampolines. As an injury lawyer, I get those calls far too often. All right, next one. Kid fell out of my tree. Are we liable for any injuries? This should be good. Had a barbecue for work at my house. My coworker coached his kid to climb a willow tree on my property. Usually not super tall. I don't know how tall it was. Well, I don't know how big willows get, but my weeping willow in our backyard, not so big, and I did climb that tree. The kid made it probably 20, 25 feet up, bigger than mine, grabbed a dead branch, and it snapped, causing him to fall out of the tree. Luckily, the kid appeared unscathed. That's good. No broken bones. Really good. Coherent. Fantastic. Another one of my coworkers' spouts is an EMT and said he looked fine. All right. My wife is worried that we're liable if any injuries come from the fall. Are we liable even if the parent allowed him to climb the tree? Well, the answer is you could be, but maybe not. First of all, let's talk about these cases. Everyone wants a clear answer. There's 2 different ways you can get an answer. One is legally and the other is factually. Let me explain that. Sometimes you are legally responsible for certain things that happen. If you have a ditch that you dig in your backyard and then you have people over for a barbecue at night with a ditch and someone falls in that ditch, while there's still some factual components, you literally created the hazard, failed to notify people of that hazard, and someone got hurt in that hazard. There's some factual assumptions I'm making, but you got a problem legally. But a lot of these questions are more factually based. For instance, did you know that there was dead branches on this tree? Probably not, but did you? Had you seen other kids climb this tree and have a bunch of people falling and breaking? Maybe, probably not. Was the parent aware of everything you were aware of? Maybe in this case, because they looked up in the tree. Sometimes though, there's facts that you may not be sharing, not necessarily intentionally, where this was a little more of a danger than you shared with the guest, and that's why the guest let the kid go up the tree. Here's the bottom line to all this though. Injury claims like this are all hypothetical. Why? Because it looks like the kid wasn't hurt. Generally, really bad injuries, you know they're really bad almost immediately. So this sounds like one of those situations where a kid was being a kid, ends up not hurt too bad, and learns to be more careful. So in the end, not a terrible thing. And this is what I would say to your wife. There are bigger things to worry about. The kid doesn't look like he's hurt. You probably didn't do anything wrong. And even if you did with injuries this small, everyone's likely to move on and go their own way. And this kid will have learned a little bit more about being safe while climbing trees if, he chooses to do it again. Someone asked Reddit, but they're going to get an answer from me too. Lawyer deliberately left 1 page out of a PDF document sent over in discovery. Those that don't know what discovery is, during the legal process, the sides have to exchange information. And during that, there are responsibilities about what you exchange. And that process, the give and take of names of witnesses, documents, that's called discovery. I am currently in a lawsuit. The opposing side's lawyer intentionally left out 1 page of a PDF document in his discovery documents. I'm always stopping because we assume the worst in an adverse situation. It'll be interesting to see how we know it was intentional. The single page left out was something that would hurt his case tremendously and strengthen our case. The document was in the CC&Rs for the HOA. CC&Rs are when you buy a house in many places, there's covenants, conditions, and restrictions. So like in some neighborhoods, you can't put up a basketball hoop. In other neighborhoods, it says what color you can paint your house. There's all sorts of limitations. You're going to be in this homeowners association. You have to do things our way. They suck. But anyway, here we go. It is available for download on the HOA website. I had downloaded the same document myself when researching and found the page which strengthens our case. He would have had to deliberately edit the PDF to leave out the page. Ooh, maybe. Get to that in a second. I was shocked a lawyer would actually do this. I hope you were shocked. That speaks very well of how you felt about lawyers and the way they would do it. I would not be shocked, but I would be surprised. And I don't think most lawyers would do that, but I wouldn't be shocked because I think a small number would, unfortunately. So I was shocked a lawyer would actually do this, and he just thought we wouldn't do our own research, I guess. What is the recourse for this? Lawyers shouldn't get away with something like this. Has anyone had something similar happen to them? Any lawyers on this subreddit want to weigh in? Boom, I want to weigh in. Okay, number one, if you can prove that a lawyer intentionally hid things in discovery, that lawyer could be in big trouble and it could help your case. See, there's two things at play here. One is the rules, basically the rules of the game in a case. And if you have a document that you're supposed to give me and you sneak out the worst part of that document and you give it to me as if you've given me everything, related to the case, I might be able to go to the judge and go, Judge, they cheated. They got caught cheating. They cheat worse than Connor Stallions and Jim Harbaugh in a football season. They are the biggest cheaters of all time outside of Ann Arbor, Judge, and there should be consequences. And unlike the NCAA, the judge would probably say, you know what? You tried to cheat and you know full well you can't pull a document out. So related to your case, the judge may say, and therefore, and there's a lot of therefores, but one could be, and therefore you win the case. Not likely, but possible. Another could be, and therefore this thing he pulled out, that one part of your case is now proven. You win it. It's limitless. It could get down all the way to very, very minor things. I won't make you bring in someone to get this into evidence. There's all sorts of things. That's one area. Could it help your case? Could, if you can prove it. The other is ethics. Lawyers have to be ethical. You want to know one reason why most lawyers don't cheat like this? It's because most people act in their own self-interest. And as much as they want to fight for clients, it's a really big deal if they get caught cheating like this and they can lose their license to practice law. If you can prove the lawyer did this, he could lose his license or be suspended from the practice of law for a period of time, or even a public reprimand. Really big deals. So there's two different things, both big, that could happen if you can prove it. Can you prove it? If your lawyer brought this to the court on your case and referred to the state bar, this other lawyer has some questions to ask. Now I'm going to tell you, a lot of times there's another side to the story. Maybe his client got it for him and took it out. Maybe no one took it out, but he's an old school lawyer. He prints everything out and that page got taken out. Maybe the page you thought was so vital is not a page anyone else thought was vital. Maybe they think he did it, but they can't prove he did it. Number two, in a real world setting, I have from time to time caught lawyers doing Connor Stallions type stuff and cheating and violating the rules. I'll be honest, right or wrong, I have never reported another lawyer to the state bar, even though I've had grounds to on multiple occasions. Almost never have I brought things to the judge, although that's happened where it was so clearly related to the case that it could help my client in that case. I just think very often these things that get us so mad, rightfully so, are very difficult to prove and they just drag you down, into the mud, so to speak. Be careful. If you come across as reporting things that don't look like they are true, now you look like the bad guy. You have more questions? You want to see me do more of this? Answer some more questions as an actual trial lawyer? Let me know your questions. I'd love to hear your feedback. Follow, like, subscribe, and let's do this some more.